do that. Okay, so basically what we're looking at when we are looking at a new venture, or when an investor looks at a new venture, he looks at exactly how can we obtain commercial success, right? So commercial success is all about the competitive advantage. Does the company have some sort of competitive advantage over its competitors in the market in general? And it's finding the correct scheme of how to beat the competitors, but still maintain as much rights in the company as possible. Masha? Now, if you look at the VC goals, of course, we want to have a successful investment. So what is a successful investment? Basically, the first thing we want to look at is how do we maximize our return on investment, right? We put money into the company. How do we maximize it? So how do we create and maintain value in a very competitive world, in a very competitive field, especially in medical devices, and especially in the algorithm landscape? Because we saw in Greg's presentation how many patents are actually granted and how many patents are prosecuted each year in this field. So one of the ways to look at it is how do we use this IP to create and to maintain the value in the company. The next thing is how to maintain exclusivity in the technology. One of the ways to maintain exclusivity is, of course, to build a proper IP portfolio to help us to monetize on the company's assets. The next thing is, of course, to create effective barrier of entry to competitors and to curb competitors' competitions. IP can be a very helpful tool in doing that, in order to, to create a barricade or to create walls against competition, because it disrupts whatever a competitor may be doing or maybe in the field of development is doing. Another thing is to hedge against technology and R&D risks, right? Because we saw that a company has maybe one track of development, but it also can have several other tracks of development. And using this IP, we can actually use it to hedge against R&D risks or technology risks. The basic thing that an investor will look at, first and foremost, is the correlation between the business plan of the company and the IP strategy, if there is an IP strategy. I've encountered many cases in which a company goes to the road, try to get investments coming in, but they don't have any kind of IP strategy built in. An investor will first and foremost look at the IP strategy, what has been done and how it correlates to the business plan, the current business plan of the company, and the future plans of the company, because companies do change and business plans do change. We look at the relevance of the IP to the business model. As we said, how can the IP serve the business model, and how can the IP actually benefit to the business model? How do we correlate between the IP and the R&D plans? Is the IP going hand in hand with the R&D process? Is some sort of diversity in the IP needed because of different R&D paths in the company that the company is looking at? So we need to look at that correlation. We also look at monetization, how enforceable our patents are. Okay, because we heard previously Erez talk and Greg about the possibility to make money from patents. Patents can be monetized if they can be enforced. So how does our patent live in this competitive landscape, and how do we enforce our patent, and can we monetize on such enforcements? We also look at, of course, blocking competitions. How does the IP effectively block competition by the scope of it? What does it protect? How strong is the protection we have? We will see an example in a very short while. We also look at how to monetize off-focus IP, because companies, especially new companies, create a lot of data. New companies and new ventures create mostly data. They don't create as much products as they create data and knowledge. And sometimes we have IP assets or patents that are not in the main focus of the company, but they can be monetized by out-licensing, for example, by selling the relevant patents to somebody else who's interested in. And of course, we look at the balance between the IP assets that the company has. The company has many assets, the two most important of which are patents, of course, and trade secrets or know-how. And the investor will look at the balance between these two assets, these two main assets. There are other IP assets also, but they have a less significance in high technology based companies. And the whole issue is how do you balance these two types of IP assets? Because, and I hear it a lot from companies who are dealing with algorithms, they say, well, we don't know if it's patentable and we want to keep it as a trade secret. Basing your entire strategy on trade secrets or just relying on know-how is a business today. Because first of all, we live in a very highly regulated world, okay? Especially in the medical devices field, everything is regulated, data is being exposed. Okay. Basically, most of the data is being exposed through regulatory processes, okay? We have to file data to different legislations, and data is being exposed. So by the mere exposure of the regulatory data, okay, know-how is being exposed and trade secrets can be exposed as well. Another thing to look at is today, the workforce is very fluid. You have one worker working for you today, he comes out and then works for your competitor tomorrow. And the data that is within the worker's head, you cannot take it out. Okay, so the data goes with the worker and you can sign in whatever non-competition agreements that you would like. It's not effective and it's not enforceable in court in most cases. So relying only on the data that resides in your worker's head as know-how is a risky thing to do. And many companies do not imply proper confidentiality rules or regulations or procedures within the company. So a lot of the data is being exposed unintentionally. Reverse engineering is also an issue. Whatever can be reverse engineered cannot be maintained as a trade secret because somebody can reverse your technology and see exactly what was done. So it cannot be kept as a trade secret. So do not rely only on trade secrets. It's a very, very risky thing to do. So what do? We go to patents. Okay, and that's the main thing an investor will look at. You look at your patent portfolio or your IP assets. And the basic thing that an investor will do is a due diligence process. Now, the main part of the due diligence process or the IP due diligence process that an investor will do, he will do sorts of a SWOT analysis that we all know, but with a specific focus on IP issues. For example, he'll look at the strength of the IP portfolio. Do the patents present a substantive barrier of entry to competitors? Is it a valuable asset? Is it sufficiently broad to cover not only what the company does, but as Erez truly said, what other people can do with your technology? Because you have to remember that patents are not a positive right. They're a negative right. A patent prevents somebody else from doing what you got a patent on. Okay, it's a very different thing. So when you're looking at a patent, it's not only on protecting what you do, but also looking at the technology and looking at what your competitor will be able to do with the technology in 2 years' time, 3 years' time, 5 years' time, and trying to protect that in a patent application. So from this, you can have a look at the broadness of the scale of the claims, okay, or the broadness of the patent. Does it actually prevent somebody else from coming into your technological field? Are the rights enforceable? Are trade secrets or valuable? Okay, we'll see that in the opportunities as well. We also look at the weaknesses. Are there gaps in the technology or are there gaps in the IP? Okay, can something be done to improve the IP position of the company by creating more patents, by maybe filing continuation applications as we heard from the previous speaker? Can know-how be maintained if we want to rely on know-how, or certain aspects are maintained as know-how? Are they properly maintained within the company? We also look at opportunities, of course. What sort of measures can we take to maximize our IP value? Again, maybe filing continuation applications to broaden the scope. Maybe we have some sort of monetization of off-focus IP, as we talked about before. Is there any know-how that we can convert to a valuable IP asset, to file a patent on something that we thought about maintaining as know-how, but can be patented and can be used as an opportunity to broaden the scope of protection that the company has? And of course, we also look at threats. Mostly, as we heard previously, we mostly look at third parties' rights, what is called freedom to operate. We have to make sure that the venture has the freedom to do its business in the field, and it does not, infringe on anybody else's patents. Does the company have all sorts of related patents? Okay, maybe the company is relying on a licensed technology by somebody else that gives us all sorts of limitations on the deal. Is there any know-how leakage, of course, that we need to hedge, and also, and many, many other things that we do as part of this SWOT analysis. We want to look at the IP and its meaning in investment. Now, if you look specifically at the AI and algorithm-based technologies, it's all about the value, the assessment of value of the patent. Okay, because there are many patents out there on algorithms, there are many patents on AI technologies, but are they really of value? So the investor will look at 3 main points. The first one, again, as discussed, is the scope. Is the scope relevant to what the company does now? Is the scope relevant of what the company is planning to do as part of its R&D ventures? Or is the scope relevant to somebody else so we can monetize on our inventions, on our IP? Okay, what can a third party do with the technology? Does it has the potential of falling within our patents or not? Okay, so that's the scope. We also look at frequent practice changes because, a patent process takes many years from filing to grant, and during that time, the practice in patent offices change. So we look at what are the prospects. If we have pending patent application, we look at what are the prospects of getting a patent granted, and what is the foreseen scope of the patent that can be granted, and does the patent application have the desired scope, or maybe something should be done in order to change it or to modify it if possible. And we also look at the enforceability issue. Again, as we heard before, can infringement be proven in a competing product? Or can the rights be enforced? And these are two different topics that we look at as part of this due diligence process, and they determine very much the value of the patent itself. Because a patent that is hard to enforce, or a patent in which we cannot prove infringement, has less value than a patent for which we actually can prove infringement of a competitor, and we can go and attack them in court and maybe get some royalties, or maybe stop them from doing business altogether. And let's look at a very, very generic example on patent enforceability. Let's see a generic claim that we see all the time. We have a system that has three components. We have the clients, we have the server, and we have something in the cloud that's doing the computational thing. And this is a typical claim that we see: a system for purpose X to do something, comprising the server and a plurality of client computerized devices, the server being linked to each of the clients through a network. Nice, very nice. Perhaps we will be able to get a patent on this claim. However, this patent is not enforceable. This claim, we cannot enforce it by any way, because the way the claim is drafted, we have three different infringers, each one of them doing only a part of this process. If you don't have a single infringer, if there's no one that is doing the entire scope of your claim, you don't have an infringer. And this patent cannot be enforced, okay? Because you can't catch an infringer. So with careful crafting of the claims, as we heard from Greg, proper measures can be taken to make sure that your patent is enforceable, that you will be able, on the one hand, to get a patent, but it can be also be enforced and can stop infringing acts. It's all about the claims, as Greg said. In the world of today, you have to know how to craft your claims in order to get the maximum possibility to catch infringers as you go along. And the last thing we'll see, it's the freedom to operate. Okay, this is a very, very important part of the due diligence process that the investor will look at. Does the company have the freedom to operate or do its business in view of somebody else's already granted patents or already granted rights? So we look at two main things. First of all, we have to remember that in the world of today, injunctions are very, very rare. Courts do not go giving out the injunctions to stop somebody else from doing business so quickly. So FTO becomes more of a business issue. Can we mitigate if an FTO issue arises? Can we mitigate it from the business perspective? Can we approach the owner of the patent and get a license on it? Can we buy the patents? Can we do some sort of reverse engineering to go around the patent? So it becomes a business issue and not a legal issue per se. Also need to remember that in most cases, systems are complex. And in order to do a proper FTO and to have a bulletproof vest around your technology, you have to break down your technology into many, many elements and check if you have FTO issues in each and every one of these elements. This is an impossible thing to do because systems are complex. So what we need to do is to focus on key elements of the technology and look at them, because otherwise we will find ourselves in an impossible task trying to clear everything out in the process. We also, besides looking at third parties' patents, which are the main risk in FTO issues, we also look at related parties' rights. It's not patent, but rights. Any kind of third parties that the company has relations with, okay, can it pose an FTO risk? For example, a company uses advisors. Does the advisor have some sort of rights in the technology? Does the advisor have patents on its own? Commercial partners, former employees may have rights in the technology that is not acknowledged. Licensees and licensors, of course. Are there any kind of limitations through agreements that the company has done? Okay, maybe other investors, maybe advisors that can have part of the technology or part of the assets. So all of this is going into the due diligence process, and all of this can have an impact on the value of the IP and on actually the possibility of an investor to go into the deal and actually invest money in the company. So if we look just to sum up what is actually involved in the due diligence process and what will an investor look at when going into a potential investment deal is, first of all, we will look at what was done. What was done to generate value from the IP point of view, which is looking at the status of the existing IP that the company has. And of course, going to, as we discussed, the correlation between the IP strategy that the company has and its business plan, whether the IP strategy suits the business plan, maybe the IP strategy should be changed. And I commend Erez on doing this IP forum or IP meetings, because IP strategy needs to be changed frequently. And IP strategy is something that you have to look at every few months, depending on the status that the company is, on the stages of the R&D, on the stages of development. And the IP strategy should go hand in hand with that, okay? So all the time, look at the IP strategy, look at how you can revise it to modify it to suit your business plan, to suit your actually business status at that specific point in time. And the other thing the investor will look at is what we can do, what can be done with the assets. Other two, by looking inward to increase the value or improving the IP that already exists in the company, or looking outward in how do we get money from it, either by enforcement or by monetization of giving rights to somebody else. That was me. Questions? Good. Curious.
Yeah. For doing work for VCs that are investing within Israeli startup companies, how many deals, or in percentage or in general, are really going bad because of IP issues?
Unfortunately, a lot. The Israeli mentality of going fast and going strong does not always, go to the benefit of the companies themselves, because sometimes, and in most cases, especially in the field of algorithmics, many companies start the IP process too soon. They start from a starting point which you don't have a real understanding of the technology, they don't have a real understanding of what they have, and trying to, obtaining IP assets which are not relevant to their actual business can damage the possibility to get an actual investment, because the investor will look at what can I do, and how is the company protected, and how is the company protected in its field of business and the relevance to the technology. If the patents that maybe you got great patents, but they're not relevant to the business because it was too early, they're not going hand in hand in your actual state of R&D or actual state of the product that you're going to sell. Unfortunately, we see too many cases. But on the other hand, we do have cases in which a company comes with a very bad patent portfolio, but the company has enough know-how and have enough assets and enough R&D processes, enough creative people inside that you can actually take this know-how and turn it into a valuable patent. And then actually a deal can come along, because you tell the investor, look, I looked at the patent portfolio. The patent portfolio is not worth a lot. But if you do some sort of measures in the company to take this know-how and convert it into valuable patents, then you will get valuable protection. And many deals have been based on that, not on the actual patents that were in the company at the day of investment, but on the potential of what the company can have based on its actual knowledge. Yes. It can, because mainly what the VC is looking at, of course, is again increasing ROI. So in many cases, people from the VC will be taking part of the decisions going forward. There may be some milestones that are built into the investment agreement. So the company needs to do this and that according to the VC in order to get the next step of the investment. So the VC does have some sort of way to influence the IP status of the company and the IP assets of the company. To tell you that we see that a lot, Not too much, but we do encounter cases in which the VC dictates actually certain milestones and certain achievements in the IP field that the company needs to have in order to get the next quota of investment.